Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Afternoon.
Good afternoon.
Do we have everyone we're expecting for this?
Believe so, Your Honor.
Okay. This is in the District Court of Ellis County, Kansas. We have two cases, 25 CR 149, 25 CR 277. Both captioned State of Kansas versus Gwen Elizabeth Leglighter. May I have an announcement of appearances, please?
May it please the court, the state appears by Aaron J. Cunningham, Ellis County Attorney via Zoom.
Your Honor, the defendant is appearing personally by Zoom from the Ellis County Jail. Her attorney, Chris Biggs, is appearing by Zoom from his office, Manhattan, Kansas.
Leglighter, you understand we're doing this hearing by Zoom?
Yes.
Are you agreeable to doing your hearing by Zoom rather than in person?
Yes.
If at any time you need to speak with Mr. Biggs, raise your hand, get my attention, let me know, and we'll put you in a breakout room.
Okay.
Do you need to speak with him before we get started this afternoon?
I don't think so.
Okay. We're on for your motion to set or modify bond, Mr. Biggs.
That's correct, Your Honor. I represented Ms. Leglighter and entered an appearance in her first case number in this matter. And subsequent to that, she was picked up on another case on a probable cause arrest. And a bond was set on that second case when she had a first appearance. But on the first case, there was apparently a notification from the court services office to the jail that said there was a court services hold. Ms. Leglighter had contacted me and said, I can bond out on my second case, but I can't bond out on my first one because they're saying I have a hold. And so I inquired about that, and what I learned was that there had not yet been a hearing set for a first appearance on that first bond that she was being held on a court services hold. And I guess that was for a bond violation, but there was no motion at that time filed, and she had not had a new bond set.
Okay.
So I had some communication with Mr. Cunningham about that, and he was explaining to me, and I know different jurisdictions do it differently. What I'm used to is if people have if they're arrested, if there's a bond violation, the state will file a motion to revoke the bond, and sometimes a warrant will be issued with a new bond on it. And then there'll be a hearing held to see. But in this case, apparently just the court services office calling over to say hold them was sufficient to hold her without a warrant or a motion being filed by the prosecutor, which was different in my experience. I haven't had a chance to look at whether that's valid or not, but it's certainly contrary to what I'm used to. But in any event,
Well, the court also, Mr. Biggs, filed a sua sponte order releasing the cash bond of the first bond back to her father at his request. She was in jail. The father who posted it came in and wanted his bond back. So it was returned to him, and the jail was informed she had not posted bond on either case.
okay, so the bond, essentially the person that posted the bond came in and asked for relief on the bond.
Yep. Her father wanted his bond money back, so it was released to him because she was sitting in jail.
Okay. And and when that was done, I assume that was before I'd entered my appearance in her case. Probably.
It was after.
September 17th.
We sent you a copy of it.
Okay.
Yeah, September
So
17th. We sent you a copy of the order.
okay, so what happened was
What we're at is she's just got two possession cases. She hasn't posted bond on either one, and you've got a motion to modify the bond.
yeah, what I'm asking for, Judge, is asking that they be combined. And I'll tell you what the circumstances are. I mean, my client has a possession case. She was out on bond. She got stopped and was charged with another possession case. She has clearly figured out that she's on their radar, and it behooves her to keep her nose clean, for lack of a better expression here, because this would only make matters worse if she were to get in trouble and continue to use.
I'd like a chance to go through court service downstairs.
Ms. Legleiter, do you need to speak with your attorney?
I'd like to speak to the court.
Well, right now, it's not your turn to speak. Right now, it's your attorney's turn to speak, and I would caution you that you'd be better off to speak to your attorney before you just start blurting out, okay?
Maybe I could finish, Judge, and if she still wants to talk to me, then that's fine.
Okay.
But she has a job, and her concern is that she's going to lose it if she's not able to get out fairly quickly here. And she believes that she can make a reasonable bond. And obviously, with what she's charged with, I don't think a condition that she be put on bond supervision with regular testing would be inappropriate. So with those kind of things in place, I'd ask that she be released. I will have the conversations with her, Your Honor, about where it goes from here and whether we need to take any intermediate measures on her behalf. But the bottom line is that because of what she's charged with, and I think they're both level 5s. Am I correct about that, Mr. Cunningham?
No, she's charged with level 2 possession with intent to distribute in 250277, and subsequent investigation into that matter after the charges were filed. There's additional evidence that supports the belief that she is distributing.
Okay, and I haven't been provided those yet, though, right? Probably.
No, I've not been provided those. I just found out from the detective who was reviewing the phone search this morning, just in passing.
Okay. Well, Your Honor, perhaps I was under the erroneous impression that she did not have a bond set anymore on the first case, when in fact, if you had not modified the amount, it would be the same amount it was. It was just no longer posted because it had been returned to her dad. So if that's the case, she would appear to have a bond set in both cases. And I would just request that the total bond amount be whatever was set on the warrant in the second case, or at her first appearance, excuse me. And my understanding is that prior to your new information you got, Mr. Cunningham, that allegation of distribution was based upon the amounts.
Yeah, it was based on weight up until the subsequent discovery.
And there weren't other indices there, right? Scales, money, ledgers.
I don't recall.
Okay.
And Ms. Legleiter, you've heard Mr. Biggs. Would you like to speak to him in a breakout room?
Yes.
Okay. Jess, could you put Mr. Biggs and Ms. Legleiter in a breakout room, please? Speak with Mr. Biggs in their breakout room.
Yes, sir.
Okay, Mr. Biggs.
Yes, Your Honor. Without going into details, it concerned the conversation about there not being any other indices of distribution in the car. So from our position, what we've got here is a level 5 charge, and then we have what we believe is a level 5 charge. And she does believe she can make a bond. We don't object to reasonable conditions as determined by the court. We'd ask that she be given one bond for both cases, and we don't object to bond supervision with testing, random testing.
Mr. Cunningham.
Your Honor, the state would disagree. I mean, we have a level 2. We've got evidence supporting the level 2 beyond just the mere weight. According to our bond schedule, that's a $50,000 to $75,000 bond. I'm not really sure why it was initially set at $5,000. Certainly, I think any reduction from there would be inappropriate based on the fact it is a level 2 and it's presumptive imprisonment.
Your Honor, if I may just respond briefly, obviously she's presumed innocent unless and until convicted. And this was not a crime against persons. She had a level 5 possession. She was caught. It's my understanding there were 2 bags in the vehicle. There were no other indices of distribution. Mr. Cunningham's telling me he believes he has some evidence of that, but he doesn't even know what it is. So I think it was probably set where it was based on the affidavit of a stop and what was simply found in the car. And I know there's certainly been a lot of discussion about the lawfulness of some of the presumptions that can't just be arbitrary. They have to be based on some rational explanation. You know, people do have certain amounts when they distribute, but there are also Costco buyers out there that buy multiple packages when they buy and buys in a discount if they're users, and that doesn't make them distributors. So,
well, we're getting a little off topic for today. Today's topic is bond.
I understand, Judge, but I do think consideration of the evidence is something you can consider, and that there's a distribution charge here, but what you don't have, at least with the stop in this case, is any of the other indices of distribution. Guns, multiple
Right.
cell
The
phones.
distribution is based on there being approximately 4 grams. So it's based on weight.
Yeah, and there's issues with those presumptions, and there's also the fact that people do buy in bulk sometimes, and none of the other indices are there. And I think you could look at the totality. I mean, there's a difference between this case and the one where there's controlled buys, which you don't have any here, when I understand, and somebody who's got cash, who's got a lot of drugs, who's got ledgers, who's got multiple phones, who's got all of those indices of distribution. You don't have that here.
We have text
It should be
messages
treated
and
differently
lies.
than
Again, counsel. It's alleged in the affidavit she has 4 grams. There's a presumption. She's charged with possession with intent to distribute. The issue here is bond. Now, I've heard that she might have a job. I haven't heard what that job is. I haven't heard if she has a place to stay.
Your Honor, she works at a convenience store. Last time I talked with her, she still believes she had the job, but she needed to be getting out as soon as possible. I believe she still has a place to live. It's been a few days since I've talked to her, so I have no objection to the court inquiring of that.
Has she applied through court services for bond?
She has, Your Honor.
Okay, and court services position.
So the application she filled out, I believe, was on September 16th, if not the 17th. And she documented that she could live with her father, who posted the bond in the initial case that we have. I confirmed with him, and he said that she can reside back with him, even though he pulled his bond. And then she documented that she was not employed anymore at the Loves in Ellis, so I did not call to verify any employment because she put she was unemployed.
Okay. And Mr. Cunningham, your affidavit indicates you think she's going to be an H or an I.
That's correct.
Okay. Okay. Well, the bond is set at 5,000 in the second case. The bond, I think, was set at 6,000 in the first case. Okay. And those are low bonds for a distribution, but that's kind of beside the point. It's based on quantity as for the distribution. She has a place to stay. She'll need to get a job, but more importantly, she's going to have to get evaluated and do treatment. So, Ms. Legleiter, your bond will remain at 6,025 CR 149. It will remain at 5,025 CR 277. but the court will allow you to post it by own recognizance to court services if you're agreeable to do that. But on court services, you're going to have to follow all their conditions of bond, and you're going to have to get evaluated and begin treatment.
Yes, sir.
Okay. So are you amenable to those conditions?
Yes, sir.
Okay. You're not going to get out until Ms. Hecker confirms with your father that he's still agreeable to your living with him.
Okay.
You will have to get a job.
I have one already lined up.
Okay. Where's that at?
Burger King.
Okay. You're going to have to get an evaluation and begin drug treatment at the direction of Ms. Hecker.
I had my sister looking into getting me an evaluation.
Well, Ms. Hecker will tell you what an appropriate evaluation is.
Okay.
Okay. You're going to be under full bond supervision, which means you're going to have to, in addition to their terms, you're going to have to obey all the laws. You're going to have to keep contact with your attorney. You're going to have to appear at all scheduled court hearings. You're going to have to be evaluated, and you're going to have to do treatment at their direction. Court services has the discretion. If they believe it's necessary to put on electronic monitoring, they can require that, and that's at your expense. But you're going to follow all other conditions of bond as set forth by court services.
Absolutely.
Including curfew, including who you can and can't be around. Those conditions, you understand?
Yes.
Okay. If you have any disagreement with what they are ordering you to do, you can talk to Mr. Biggs and he can bring it to the court's attention. But unless and until the court relieves you of the obligation, you will comply with each and every obligation of bond as set forth by court services.
Without any question, I will.
Okay. Ms. Hecker, when was the last time you spoke to her father?
At about 1 o'clock this afternoon, Your Honor.
Okay, so it was very recent.
Yes.
Okay. Then the jail can release her, but Miss Leglighter, you're
Yes.
going immediately to Miss Hecker's office.
Okay.
Don't go to SERVS. Don't go anywhere else. You go immediately to court services.
All right.
And you begin bond supervision and you do everything they require you to do.
Okay.
Okay. Any questions?
Absolutely not.
Do we have a next hearing set on this, Mr. Cunningham?
I don't know, Your Honor.
Your Honor, I think I have it on my calendar. I looked at a journal entry this morning of the hearing where I missed.
You've got a status October 21st at 11 a.m.
Right.
Miss Leglighter, you will be at that status hearing.
And I have court on the 13th, early in the morning too, for municipal, and I'll be there too.
Okay. Any other conditions you require, Ms. Hecker?
No, Your Honor.
Okay. Anything further for the record, Mr. Cunningham?
No, Your Honor.
Anything further for the record today, Mr. Biggs?
No, Your Honor. It's just good to see you again. It's been a while.
Okay. And Mr. Cunningham, if you'll put together the journal entry.
It wasn't my motion, Your Honor. But if the court's ordering me to do so, I can.
The court does, because these cases stay on track when the state continues to track the journal entries.
We struggle when we're understaffed, but I guess we'll push through.
Okay. So you report immediately to Ms. Hecker.
Okay.
Okay?
Yes.
Okay. Thank you all.
Thank you.
Thank you, Your Honor.